I am re-recording the compliance webinar that I did in September because somehow, being the technological genius that I am, the recording did not load to my computer, and that's why no one has gotten it. So finally, I'm getting there, and I'm going to record it for you now. So let me connect to the um, PowerPoint. So this is a 2024 compliance update. I'm actually going to do another one pretty soon as well, but I want to make sure I invite everyone to that. So as always, I give wolf trivia at the beginning of my webinars. Did you know that wolves have gold eyes? Do you see those beautiful gold eyes? So this is one of the signs if you're looking at another canine and wondering if he or she has any wolf blood, you look for those gold eyes, among other things. Let's see. How do I get to the next? Oh, I have to click it over here. See, such a tech genius. So my disclaimer, as usual, nothing contained in this presentation is intended to be or should be taken as legal or tax advice. The information contained herein is generally informative in nature and does not necessarily apply to any specific situation or legal need. Attendance at this presentation does not create an attorney-client relationship between myself and the viewers or an expectation of privacy or of confidentiality regarding anything you may disclose to the presenter. In this case, there's no one present, so you're not disclosing anything. So one of the things, a couple of things that I've noticed that have come up over the last year are in some of the recent cases that I've had, investigations or accusations that have been filed against clients. One of the things that is being addressed is supervision. So geographic location, and it says this on the MedBoard website that the geographic location must be convenient. My rule to keep people safe, and this has never been a problem if people have stayed within this rule, and that is that the medical director or supervising physician is 40 minutes away or less. Different mileage may be impacted by traffic in different regions, but 40 minutes is a reasonable period of time, and that's usually 40, 45, 50 miles. I always inform my clients that monthly visits are highly recommended. If the medical director, supervising physician, is visiting the clinic or visiting with the providers in the case of remote telemed or other remote providers, monthly, it usually satisfies the medical board's expectation in regard to, and the nursing board and the PA board in regard to whether supervision is occurring in an appropriate time frame. All of my clients have the medical director visit report form, which includes documentation of the requirements of supervision, which include chart review and signing. I also have clinic inspection on there. If you have a physical space, most people do have a physical space. As you know, the physician must be knowledgeable in and be able to perform all the procedures that you're providing in the practice. The physician must sign off on all new clinical hires, and those people should know, and I've said this to you all before, you've heard it, that the providers must know that the physician is their employer. I always recommend having a picture of the physician in place and available when anyone walks into the clinic. It should be on the wall, and it should be, Dr. Sam Jones, medical director. The physician should sign off on all new hires and should sign off on all new procedures. We want to make sure that all providers have signed the signature page in the front of the standardized procedures or protocols, and those signature pages should be maintained for 7 years. I used to say 5 years, but recently, over the last couple of years, learned that the boards can still come after you for 7 years. And if something happens in that 7-year time frame, they may ask for proof that the physician and the providers all signed off on a protocol for a particular procedure, if a particular procedure gave rise to a patient issue. Physician identity, again, the physician must be identified on the website, should be identified in the practice space somewhere. And I highly recommend identifying the physician on any social media pages. Most people are using Instagram. So in your bio, or if you're using TikTok, in the bio, you should have a link to the practice website, and you should have the physician's name listed there. Remember that, physician extenders and nurses should not be representing to themselves independently to the public as providers of medical services. That's why we always want to link to the practice in the bio portion of the Instagram page or TikTok page. Let's talk about employees. I've had a few issues with people having problems in regard to how employees are characterized. And I've said this multiple times. In 2018, law in California changed, and the definition of who can be an independent contractor or be paid by 1099 and who must be a W-2 employee changed as a result of the Dynamics case, which was then codified into AB 5. The rule is, if the person, for our purposes, the main thing we want to focus on is if the person needs to be supervised, which everybody does except for doctors, and if they're performing a primary function of the business, in this case, we're providing healthcare services, nurses, NPs, PAs are providing healthcare services, they must be W-2 employees. Now, if you have a separate GFE service, we're going to get more into GFEs in a second, but the GFE services that I condone have their own MSOPC structure, just like you all do, many of you all do. So you're actually contracting another medical practice to come in and provide those GFE services. So mischaracterization can lead to costly fines and penalties. We don't want to do that. All the workers need to be W-2 employees. When we have our initial Zoom, I talk about employer liability insurance, which covers you for instances of wrongful termination claims or harassment or discrimination. And this can happen in the smallest practices. It can happen where there's all one gender in a practice. I've seen it. We've had really unfortunate things happen where, for instance, in an all-female practice, people got a little tipsy at a holiday party and got inappropriate with each other. And multiple employees quit and immediately filed claims. So alcohol is not our friend in business functions, and we should have that employer liability coverage because these cases can be very, very costly to defend. New laws in California, all full-time employees must have 5 days of paid time off per year. And you may or may not know about the CalSavers program. Your payroll company should have told you this. I think the PTO is all employees. The CalSavers is 5 or more. If you have 5 or more employees, you have to have access to either CalSavers or an equivalent, which is a retirement savings plan. It doesn't cost you anything as an employer. CalSavers is the state program. You can use that, or if you've got a financial planner that can provide you with an equivalent alternative, that's also fine. Good faith exam. There's been a lot of noise around good faith exams lately, and a few new companies have arisen that are purportedly offering good faith exam. Good faith exams in California must be synchronistic, meaning the NP or PA who's conducting the exam should be on video with the patient. Just taking pictures and reading a form, that cannot be defended. And if there's an issue that comes up with the filling out of that form or the pictures are not readable in some way, the question I always ask clients is, can you stand up in front of the board and defend that as and appropriate and, completely diligent, good faith exam if it's not done on video, especially in aesthetics where we're, looking at people's faces and their skin. And really for any area of medicine, because there's so much you can tell by actually talking to someone, even if it's not, flesh to flesh in person, but on video. And we want to be really careful about what treatments that we authorize for patients. You all do. Moscone Knox, that has to do with the corporate structure. As you know, there must be a professional medical corporation in place to practice medicine in California, or you can have a partnership with physicians, which does not include any physician extenders, mid-levels, or nurses. That can only be among physicians, and it can also be a professional medical corporation, which, as most of you know by now, must be minimum 51% owned by a physician. That's an MD or DO in California, and maybe 49% owned by one allied licensee. You cannot have more non-physicians than physicians because every shareholder gets a place on the board and every board member has a vote. And you can never have a situation where non-physicians can outvote physicians. So if there's one physician, there can only be one non-physician shareholder. If you have two physicians, you can have two non-physician shareholders. In most of the cases of my clients, there's one physician and one allied licensee on that professional medical corporation. Other issues that we have come across lately are the medical waste requirements. We're adding that section to our policy and procedure manual, and we're adding a reminder on that in our next steps section in your welcome email with your compliance. My email keeps dinging, sorry. In your compliance tools that you get. So everybody has to, you can go to the California Department of Public Health and determine what certifications or registration you need in your location for medical waste. Probably most people have done this already. There are new name requirements under the DO board. They've changed a lot of things about the way fictitious names are filed. They have an online filing system now, but the physician has to actually register him or herself on the DO board, and they can identify someone else to file that fictitious name permit for them. So if you're working with a DO or if you are a DO must have their account. For the medical board, we're still doing it the old-fashioned way where we mail in the form that's wet signed in blue ink. Let's see what else. Okay, private equity restrictions. This is a big change that has happened in the medical world in California that's impacted medical aesthetics. And this bill is the reason that some of these turnkey medical spa companies like Moxie and Portrait have changed their model, because it requires a private equity group or hedge fund as defined in the bill, which, these companies, their MSO side does qualify as a private equity group or hedge fund, to provide notice to and obtain written consent from the Attorney General before a transaction between that private equity group and a healthcare facility, which could be a medical corporation, like their overarching medical corporation that they used to have, or your medical corporation, provider or provider group, as those terms are defined in the bill. Essentially, this new law is why, if you're working with any of those companies or have worked with any of those companies, their structure has changed, and they're scrambling to look for other ways to generate revenue because they can no longer lock you into their corporate PC and their corporate MSO. They are typically offering buying power, which may or may not provide you with an advantage, and that's up to the individual to determine that. I'm very nervous about them providing legal structure and legal documents, because that's a job for lawyers. And every situation is different. Like every client I work with has a slightly different situation, and we tailor our documents and structure to the client. And it's not, it's like going on to, Legal Doom and setting up your entity. And if you've done that, you know that I've had to work hard to bring things into compliant in most cases. So we want to stay in our lane. You know, like I always say, and many of you have heard me say, I'm not going to go home and inject Botox into my forehead tonight, and you're not going to practice law, and neither should other lay companies practice law. On the private equity restrictions, it's very onerous. This doesn't necessarily affect you, but just in case you've heard of this bill and had questions about it, the private equity group must give the Attorney General 90 days notice before the transaction. They must consent to a hearing. They have to jump through all of these hoops in order to have that type of a situation authorized by the Attorney General. There are a lot of changes in business in general from the federal and state level because evidently there's an upsurge of money laundering. So, you know, when like the FinCEN beneficial ownership reports that we're filing for all of our clients now, it's what we do this year, starting this year upon formation, and we're doing it before the end of the year for all clients who were formed before 2024. There are lots of restrictions being put in place to monitor, you know, where money's coming from, what money's being used for. There's actually a Texas case right now that's challenging this FinCEN beneficial ownership report requirement, saying that if the government is overreaching and they're invading the right of privacy to the companies, which is an unarticulated right in the US Constitution. Getting into legal nerd stuff, but at any rate, it's being challenged right now. But until it is found unconstitutional, we are going to comply and continue filing the FinCEN BOIs. Here are other, you can take a look at this. You can pause the PowerPoint and read it if you're interested, but these are things that they're just restricting. The idea is to restrict private equity or non-medical entities from asserting control over the way healthcare is delivered. And that's the reason for all of these rules and laws around the practice of medicine. You know that regulatory compliance is my number one objective with you all, because your licenses are first on my list. And the boards, you know, the state of California and other states want to make sure that patient care comes first over revenue production. What I want to help you do is comply with those rules so you're providing good patient care and providing you with the tools so you can generate revenue and create a future for yourself as well. That's what I try to do when I set these structures up for you. At any rate, you can read this. It's really not like, for instance, let's go to this one where it talks about selecting, hiring, firing physicians, psychiatrists, allied health. So private equity shouldn't be doing this. And in a lot of these continuity agreements that are being drafted for MSOPC structures, it does give the MSO side the ability to influence the hiring and firing of clinical staff. This is why I don't use continuity agreements. I use the physician and allied licensee shareholder agreement instead, or just our MSA. If you have any questions about any of these things, you can always ask me, but trust that I'm monitoring this and making sure to the best of my ability that your practices are safe. I did have an incident of an issue with someone providing a mobile IV service at someone's home where there was, unfortunately, an assault. This is one of the risks that we have when we're going into people's homes. I have clients who are very safety conscious, and they have very stringent rules about how home visits are conducted. And I urge you to put those type of restrictions in place if you are doing any mobile services, IV or other services. And as you know, you need a consent from the patient that says they're being treated in a non-sterile environment. We are conducting compliance audits upon request. And these are the things that we cover for clients that we didn't set up, or clients who we may have set up a long time ago and may have forgotten some of these things. These are the things that we check for each entity. We want to make sure that your names are properly registered, that your minutes are up to date. Having minutes up to date is really important for maintaining, adhering to the corporate formalities. Your stock certificate, stock transfer ledger, we want to make sure all these documents are in place and you have them, because you're going to need them if you ever get audited by the board. LLCs, we need fewer documents. For your agreements, these are the things that we would be looking at. We're looking at whether you have your standardized procedures. We want to know what procedures you're offering, sample of your doctor meeting notes, list of the employees and license type, to make sure that you don't have an abundance of PAs or furnishing NPs, whereby the doctor would be supervising more than the statutory limit. And then when we look at your marketing, how you present yourself to the public is monitored by the boards. For instance, I mentioned having a link to the site, the website for the practice on your social media accounts. How you represent yourself to the public, you must have if you're representing yourself as a healthcare provider, you have to have your full legal name that's on your license on these social media sites. And so these are the things that I wanted to go over for the end of 2024. I actually have another one coming up soon where I want to talk about a few other things, like how to handle a patient complaint. I've had this come up a few times recently. And, nipping these things in the bud and handling them right from the very beginning can prevent them from escalating and prevent that patient from causing you a bigger problem. As with all presentations, there is an end. This is the caudal gland, the little black spot in the tail of the wolf, and that's a scent gland that wolves have. So this is your second level of wolf trivia. If you have any questions, feel free to email me. I'm very available to answer questions. And I hope you're having a lovely holiday season. And I look forward to a really fabulous, healthy, and prosperous 2025.